Hello everyone, my name is Winnie.
My name is Vivien.
You're watching ANAH X Gallery Series 4th episode hosted by the two of us. We're honored to have Silvia Beltrametti, a freelance intellectual property lawyer and lecturer at this Department of Art History, Theory and Criticism at the School of the Art Institute of Chicago with us today. Silvia's area of research and teaching includes matter related to intellectual property in the creative industry and the intersection of art, the art market, and the law. As a recipient of numerous awards and grants, Silvia has served as a legal consultant at the UNESCO Cultural Heritage Protections Treaty section, and in 2019, she was named an emerging leader by the Chicago Council on Global Affairs. Let's welcome Silvia. Yay.
Hello everyone, and thank you for tuning in today. I'm really excited to be here and to be sharing some thoughts and tips about how to think about intellectual property and how to best protect your intellectual property capital as you're sailing through art school and prepare yourselves to work within creative industries. So I grew up in Milan, in Italy, where art, fashion, and design have always been part of my everyday life, and creativity in those fields has truly been at the forefront of innovation for a long time. So when I attended law school in the UK at the University of London, I was immediately attracted to the appeal of rationalizing the protection of creative efforts as regulated by intellectual property laws. It also helped that I had a really good professor back then, so people do make a difference. I then started working in that field, mainly in connection with managing the IP portfolios of large luxury brands. And when I moved to the US, I continued to work in this line, mostly in New York and Chicago.
Maybe in school or like after you moved to the US, is it for your career or like is it just like you wanted to try different things in a different country?
I wasn't sure whether to remain in the UK, as in the UK you have to choose between becoming a barrister or a lawyer who works at a law firm. And I felt like a master's program in the US in law was just going to provide me with the flexibility to practice in both countries down the line. And I was also really fascinated by how creative populations operated in the US, and that's so I came over and I'm still here.
Have you encountered any like very like memorable or like very challenging cases here?
So that's a great question. So a particularly fun but also difficult case I worked with was when I was back in London, but the company I was representing was mostly based in the US. So it concerned a jewelry design by someone called Heidi Klum, a former supermodel from the 90s. She modeled for Victoria's Secrets. So her jewelry designs, or these ones in particular, resembled the famous four-leaf clover design motif that had been created by Van Cleef and Arpels in the 1960s. So I was working on behalf of Van Cleef and Arpels, and they had been, we had been taking great care to file for copyrights and trademarks in connection with that specific design, the four leaves clover, for decades at that point. They were part of a collection called the Alhambra collection, which was inspired by the Moorish quatrefoils of the Alhambra Palace in Granada, Spain. And they were also our bestsellers, and they still are. So we had invested a lot of time and money in protecting that design. So we had a pretty solid case that we could present when we found out that Heidi Klum was doing something really similar. So even if those designs were not the most creative ones, they truly had settled into the consciousness of buyers, and they had become an iconic product of Van Cleef. And anyone with a minor interest in, even a minor interest in jewelry, would associate that clava shape with Van Cleef. So long story short, Heidi Klum lost and had to discontinue her line, even though she produced a series of diaries as evidence showing that the clava motif came from Gothic churches around Europe, like it was cast in window frames. But also, even if the designs were not identical matches, Van Cleef argued that consumers would be confused if her products would be allowed on the market, and it could have also opened the doors to many more copyists. So I would actually say that this case is representative of a lot of work I did and I still do now. I help creators in any ambit to protect their intellectual capital. So as long as their creations are original and they fit the category for protection, and we can, I've been talking about jewelry, but also fine art, photography, sculpture, music, drama, all artworks within those fields can obtain copyright protections.
Can you tell us some of the basic IP laws?
Oh, sure. Of course. Yes. So there are three main types of protections that fall under the umbrella of intellectual property. So there's copyrights, trademarks, and patents. Copyrights apply to most content-based creations, such as book, plays, photographs, again, artwork, music, sculpture. And it gives the author of an original work the exclusive rights to its use, reproduction, and distribution for his or her lifetime, plus 70 years in addition to that. So also adaptations and derivative uses are encompassed. So for instance, if you have written and published a novel, in order for someone else to turn it into a TV series, they need to get permission from you and pay you a licensing fee. Or if you're an artist who produces prints and your friend wants to place that contact on a t-shirt and sell it at a pop-up store, they cannot do it unless they strike a deal with you. And if they still go ahead and do that, you can complain. So very importantly, this changes if you're employed by a large company. So in those cases, under your employment contract, and think of an employment relationship with someone like Disney or Leo Burnett. In those cases, you would give up your IP to them automatically through that contract. So the copyright won't go to you; it would go to them. So pay attention when you sign up with large companies whose business it is to create copyrightable contents. All right, so trademarks are next. So in essence, those are logos, and trademark law protects the use of such logos in connection with a specific business line. So replicating those logos, implying that the goods or services that originate from a specific company, when that isn't true, amounts to counterfeiting. So you cannot sell any of your fashion designs under a label that reads, Prada or Christian Dior. But that's probably obvious. And patents are more complex and not particularly relevant to this conversation. They mostly, though, apply to technical inventions such as software, medical equipment, but also to the design of sneakers or athleisure wear. So they give out the exclusive right to a product or a process that provides a new way of doing something.
Like you mentioned, like there are companies like almost like conglomerates like Disney that they will just ask you to give up the IP when you work with them. Like, and definitely like artists, they would also like source inspirations from others' work as well, and sometimes maybe like go on and use others' creation to incorporate into their own projects. And what happens if artists just incorporate work of others as they go about their own creations? Would that violate anything?
This is a brilliant question that really goes to the heart of what copyright means. So thank you for allowing me to answer that. So in short, if the artwork, song, or any other element that you're attempting to include in your artwork is not under copyright anymore, you just don't need to worry about it. Think about a Shakespeare verse or a cutout of the Mona Lisa or a recording of an old song. You can use them in your work, and you don't need to ask anyone for permission. But if the work is still under copyright, you may need to familiarize yourself with the doctrine of fair use. So fair use is a defense to copyright infringement, and it is a truly important element that enables creativity. It allows creators to produce protected content to use protected content in other contexts, and there are many such contexts. So, for instance, in the context of teaching. So when I lecture here at SAIC, I produce slides that contain reproductions of artwork under copyright. I do that all the time. Mm-hmm. And for instance, I may show you a slide that includes an image of Anish Kapoor's Cloud while discussing the implications of its creation. And I can do so, and you may think it's obvious, and indeed the answer is I can, because I utilize it in the context of teaching my class, and I use it to further the pedagogic goals and objectives that I have set for that specific lecture. I cannot use them in the context of a commercial endeavor. So even if I utilize my own photograph of Kapoor's sculpture, any derivative product referencing the cloud must be licensed by the right owner, in this case, Anish Kapoor himself. And you may think, but it's not in a museum, it's in a public park, so that doesn't matter. It does not change the fact that it is the proprietary capital of Kapoor. But back to sort of more to the meat of your question, what happens if I include Kapoor's cloud shape within my own artwork and not just my lecture slide? And that gets tricky, and you need to go through the 4 factors of fair use as outlined in the Copyright Act. So there are 4 factors you need to think about. And first of all, the nature of the work. If the work is factual, it is more likely to qualify as fair use than if it is purely fictional. And the second criteria is how substantial the appropriation is. If it is minimal, if it's a small snippet within a much larger collage, it would generally be fine. But if, on the other hand, you borrow large portions of someone's work, it calls for an explanation, and that leads into the third factor, which is what type of explanation is expected. And this is the very important bit. The new work, which incorporates the existing work, let's assume it's Kapoor's Cloud, needs to provide a new interpretation or new artistic meaning as a result of the reference. So it needs to create and achieve a new artistic message. So law courts call such use a transformative use. And I guess I'll get to some examples later, but just a change of medium isn't enough. So I can't transform Kapoor's Cloud into a virtual reality or augmented reality artwork. I still need a license from Kapoor. But if I produce something truly novel with a new artistic message, that would be fine. Oh, and there's one last factor, the market factor. So you need to ask yourself if your new artwork harms the market for Kapoor's work or the copyright owner's work. This is usually pretty straightforward, but still, you need to you need to think about whether there's a market impact there.
By hurting, do you mean like bringing a different connotation to the work itself in the public's eye that's different from what the artist is intended?
Well, I'm thinking whether someone would buy my work instead of Kapoor's work, and perhaps this is one example. If it would act as a substitute, and so that's what this prong is really you know, going after. Or if I'm just trying to not pay licensing fees, yeah, to use his work when I should be. So
let's bring up like a example that probably everybody is familiar with, like the work of Andy Warhol, perhaps. Like, so we know like he referenced a lot of like pop culture images and like basically replicating them in his way of like screen printing and other practices. How did Warhol get away with referencing so many like pre-existing material?
Yes, you actually may wonder how Warhol got away with it, and he mostly did, but not always. So, for instance, Warhol stole one of his most famous images, the one from the Flower series, and he took it from a 1964 issue of the Modern Photography magazine. And he was sued by the photographer of the original photograph. So her name was Patricia Caulfield, and she took a photograph from the top of a meadow with 4 hibiscus blossoms. And Warhol reinterpreted it over and over. And today, this is one of his most recognizable works. So after he got sued, in order to make things good, he offered Patricia Caulfield 2 sets of his flower paintings in order to settle the case, but she declined, and she preferred a cash payout. So she received a couple of $1,000s, I think, and which in hindsight wasn't the best outcome. And Warhol was burnt by this situation, and after that, he truly starts working a lot with taking his own photographs. But you may also be thinking about his use of Brillo boxes or the Campbell soup, and we're moving into the trademark, the copyright as well as trademark realm when we're thinking about these examples. But truth be told, in those situations, the companies were pretty happy to get some free publicity through Warhol's work. And I'm just thinking that even if they wouldn't have been flattered by Warhol's use, Warhol would have argued that the use he made of those everyday objects was transformative, and indeed his work was seminal in the development of appropriation art, merging of fine art with consumer culture, which are 2 movements which continue to frame art making today in a major way. Thank you for asking this question. It is a pivotal case which the Supreme Court has agreed to hear in the coming year. So the case concerns Warhol's use of photographs of rock star prints taken by celebrity photographer Lynn Goldsmith in 1981. So Andy Warhol was asked to edit one of those images by Lynn Goldsmith for an article in Vanity Fair that was going to appear in Vanity Fair. So what's happening here is that Vanity Fair licensed the use of the photographs from Lynn Goldsmith for exclusive use for one article on one issue of Vanity Fair. And then they're asking Warhol to rework that image. But Warhol misbehaves, and instead of just leaving it to the Vanity Fair copy, he creates a derivative series for his own purposes of about 15 prints, utilizing and referencing the same photographs as sources, which he eventually sold on as his own work, crediting Goldsmith or asking for permission, let alone paying a fee. So Warhol has now been dead for a while, and this issue only came up very recently, and the Warhol Foundation is saying there was no need for him to pay a licensing fee because his use of Goldsmith's photographs was transformative in nature and it amounted to fair use. Of course, Goldsmith disagrees. And whereas the district court in New York sided with the Warhol Foundation, the Second Circuit, so a higher court in New York City, held that just imposing a different style on someone else's work is insufficient for fair use to apply, and that Warhol prints were derivative and not transformative. And here, in this case, the market factor that we discussed earlier also plays a role, because Goldsmith is saying, I'm living out of licensing fees. This is my job, and if others are allowed to appropriate my work for free, the licensing market for my images would suffer greatly, and not just mine, the market for licensing for all professional photographers. And so this case is still remains open, and I guess my opinion on it is that I disagree with the Second Circuit. I think that if we're looking for a new expression, a new meaning, or a new message in Warhol's work, we can certainly find it. So for instance, he's adding socially significant value to Goldsmith's original image by supplementing the image with truly a completely new definition of an icon. So he's supplementing the image of glamour girls with that of glamour boys. So Prince was one of the first glamour boys, and he's depicting such celebrities at a time when they're peaking in their fame, but before something, some sort of decline or accident happens. So the timing between fame and death is really key to Warhol's work. So for instance, the pictures he took of Marilyn were taken, so the pictures he took of Marilyn, but also the ones that he utilized, were taken just before she overdosed, or Liz Taylor's were taken as she was having an affair with Richard Burton, and she attempted suicide twice during that time. So the timing he chooses in connection with the Prince series is also extremely important to this conversation. He chooses a picture that was taken when he was at the very height of his powers, shortly before he embarked on the 98-day Purple Rain tour. And he's transforming Prince into a cultural product. He's not we see a switch from Prince as a musician to Prince recast as truly a cultural product. Anyhow, if we're looking for comment or criticism that makes Warhol's work original, there's certainly scope for this argument. We'll see what the Supreme Court will say. I want to add that this is the most important case that the Supreme Court will rule on in connection with intellectual property for creatives. And if the Warhol Foundation loses, art makers throughout the country will be hamstrung with respect to their ability to use source materials as part of their work. And this will also restrict freedom of speech overall. So I think it will have worrisome implications. And that's why many entities have written something called an amicus brief, which are supporting letters in favor of an outcome. In this case, the outcome that supports the Warhol Foundation. So we have seen Barbara Kruger and Robert Storr, or artists' foundations such as the Rauschenberg and the Liechtenstein Foundation, and dozens of art professors and some museums writing in favor of the Warhol arguments.
Wow. Yeah, I was about to ask, like, is that also why so many museums, like cultural institutions, have an interest, like paying like really high attention to this? But you covered it, and like absolutely understandable why this is such an important case that we as student artists also needs to pay attention to. So expanding on this case study, um, what is your advice for emerging artists like many of us from SAIC to consider in our own practices in order to avoid this kind of controversy from happening to ourselves?
Um, sure. So when you wish to include existing copyrighted content to your work, so be it an image or a song or a snippet of a video, a sentence from a novel, anything really, that enjoys copyright protection already, you have to elaborate on why it is important that you're using that specific material in your artist statement. So rely on a strong artist statement and make a compelling case for such use, and go deep when you explain why your work needs to include those references. And if in doubt, go back to the 4 factors of fair use that I described earlier and go through them prong by prong. But truly you're looking for a new meaning, a new message that adds socially significant value to your creation.
And then on the reverse side, so like this is about how we should avoid having controversy with or like having offending others copyright. But then when like our works are also published on website, which make it really susceptible to art theft conducted by other people, how can we what can we do to like protect our own intellectual property, right?
Great. So there are ways. So there are some compelling methods that can help guard an artist's work from being stolen. And a lot of them have been embedded within sharing platforms themselves. So YouTube, for instance, or all the Google platforms provide a fairly easy way to submit a copyright takedown request, and Instagram does that as well. This was enabled by the passing of a legal measure called the DMCA, which stands for the Digital Millennium Copyright Act, which recognized that in the digital world, the appropriation of copyrighted material would be much easier. And it was designed to protect the work of content creators who still wanted to share their work. So copyists may receive a DMCA notice asking them to take down or delete the stolen or copied content immediately. And if they fail to comply, and if you can prove that you're the creator of that material, the offender can truly have their account or website suspended, and they could be the subject of civil and even criminal penalties. So the truth is, there are ways to fight against that, but you also don't want to be spending your days monitoring the internet searching for infringers. So there are services. So a popular one for photographers is called the Trunk Archive, and it helps content producers license their work, but it also regularly screens and scans the internet for infringements. So I guess that's my answer. I guess possibly the better advice is to invest time in making your artwork creative and unique rather than running after infringement and rely on someone else to do so.
Making yourself known and like getting there so other people would just like pay attention for you. Is that right? Maybe that's a better way. Thank you, Silvia, for coming today. And thank you everyone for tuning in. We'll see you in the next episode.